welcome everyone to the webinar today. Thanks for your time. Glad that you enrolled into the webinar. Today's topic is regarding authoritarian state accountability through private sector mechanisms. I'm going to begin by acknowledging country. So we reside here on the lands of the Ngunnawal and Ngambri peoples at the ANU campus. We acknowledge the elders past, present, and emerging, and we pay our respects to the issues of sovereignty, which has never been ceded and continues to be an issue that requires resolution. Today's topic calls for a bit of a background just to help everyone gain contextual awareness. There were three different factors that motivated today's session. The first is that over the course of the past several decades, there's been an increase in non-state actors with what was historically a state-centric Westphalian international system. The non-state actors have engaged in increasing transnational activism. This includes commerce, cultural exchange, but then also an increase in activism with respect to issues like human rights and democratization. This has been countered by the second issue, which over the course of the past 2 decades has been an increase in authoritarian activity. And this has been apparent with respect to 2 dimensions. The first is an increasing level of sophistication by authoritarian regimes in terms of adopting technology, co-opting concepts like rule of law, deploying proxies, example of government organized, non-governmental organizations and corporations to engage in authoritarian regime activities. And then utilizing the transnational financial system to promote multi-sector, multinational networks crossing black market illicit activities and white market legitimate business activities. Anyone who's been involved in anti-mafia operations would recognize the hallmarks of these kinds of networks. The other component of authoritarian activism has been an increasing level of aggression. So authoritarian activities are no longer confined within borders to their own citizens, but are now going extraterritorial, where they're reaching into the jurisdictional space of liberal democracies. This is reflecting or indicating an increasing disregard of international norms, an increasing level of impunity. The third element is that there's been an anemic response by liberal democracies to this increasing level of authoritarianism. We witness governments and liberal democracies that are either unwilling or unable to take actions. It is a result of this that today we are trying to promote an exploration of non-state activism to counter the increasing level of authoritarian activity. Today is meant to just be a starting point with respect to a selection of strategies represented by our various speakers. It is meant to help our audience consider and begin considerations, creative options about ways to deploy these kinds of strategies with respect to their own causes. I am joined today by 4 distinguished panelists. First is Felicity Gary, QC. She is currently a professor of legal practice at Deakin University. Previously was working with the ICC and the Kosovo Specialist Chambers at The Hague. Second is Kieran Adams. She is currently legal director at the Human Rights Law Center in Melbourne, and previously was partner at Lee Day, and then was advisor to the Australian government regarding business and human rights. Third is Meryl Laurie White, who is at Debevoise Plimpton, previously was with the International Court of Justice and was counsel on cases before the ICJ and the WTO, and has also worked for United Nations human rights bodies and transitional justice organizations. Last is Marco Simons, who is currently General Counsel at Earth Rights International. The format today, we are progressing in sequential order. Each speaker has 15 minutes. Felicity will be first, and then when she's done, I'll go ahead and as moderator, make the transition to Karen, and then onward. Meryl will be third, and then Marco will be last. We asked the audience to provide questions within the Q&A area. There will be a Q&A session at the end of the presentations. As moderator, I'll read out the questions. I'll direct the questions to the relevant speakers and then ask for their responses in turn. So with that said, we'll turn now to the first speaker. So Felicity, the floor is yours, and you have 15 minutes. Thank you.
Well, thank you, Jonathan, and thank you for inviting me on this incredible panel of experts. And thank you to ANU. I'm just going to try and share my screen. We did test it before, so hopefully we can go back to the beginning of my slides. And like all QCs, I'm going to talk a little bit about me at the beginning, because I understand a lot of the people dialing in today are lawyers. So it's tempting to think that a lot of the things I'm going to talk about we already know. And I think what's really important when you're strategically thinking about this type of litigation or action is to accept that you don't know all things, improve your knowledge, and really engage in lateral thinking. And I've been speaking about criminal responsibility and human rights and corporate responsibility and human rights and the overlap since at least 2010 at the International Bar Association, thinking about global corporate criminal liability, and through a master's in global governance and so forth. And it brings you onto these types of cases where people without access to justice are looking for ways and means to bring litigation or to highlight what is going on where they're living. And the most recent, I'm hoping someone can put it in the chat because I can't see the chat now, was a legal memorandum that I produced with my junior, Dae Gang, for Justice for Myanmar, instructed by the Australian Centre for International Justice, that tried to look at what might be the risks for businesses involving themselves in Myanmar. So when we're thinking about state accountability via private sector strategies, which is the heading and topic of this event today, sometimes you have to think about state responsibility and corporate responsibility separately. And sometimes you have to think about the interlinking issues that can arise in these contexts. And there is quite a lot out there. I'm not going to dwell on the SDGs today, but in fact, at the IBA global event that was on today, there was a discussion around implementation of the SDGs and ethics around corporates operating in a world where we're expecting these types of corporate responsibility approaches and sustainability approaches to be implemented in some way. So for me, the overarching question in producing that legal memo was risk. Perhaps particularly when you're trying to send a legal memo to the Singapore Stock Exchange as to what the risks might be in investing in Myanmar, in that particular case in Golden City, as to what are the potential risks for legal liability, what might be the reputational damage, and what's the consequential cost implications of being connected to that particular state and its business interests. So for example, I've got cases on at the moment around illegal logging in PNG, historic slavery in the Cook Islands. And that's just such a huge question. Not just what is legal liability, but what might be the risks. And as a traditional criminal lawyer, that's about crime prevention, I suppose, engaging corporates in forms of crime prevention. So what I've tried to do with the slides today, partly because I'm speaking from the UK and it's nighttime and I wanted to make sure I remember everything, but also is to give us some dot points or some flags that we can think about if we are seeking to engage in some form of strategic litigation or strategic negotiation, what we need to think about in terms of challenges, particularly when you're advising or representing or producing documents for assisting NGOs or indeed individuals who otherwise don't have access to justice. And I commonly come across an answer to an inquiry where they don't, often there isn't enough information in the hands of the NGOs or the individuals for them to be able to present their case to a corporate law firm. So sometimes what you do in my position is I'm asked to advise or assist in some way to work up the case to a suitable point to engage in litigation. I'm not a litigator, but I can at least give some broad assistance. So you first of all have to think, in my opinion, about the international governance. It is not just human rights law or just humanitarian law, and I use just in a sort of awkward sense here. So it's not necessarily thinking about how do we prevent human rights abuses. You're probably thinking about places where human rights abuses have already occurred and are ongoing. But you're thinking about international or global governance. So you're probably going to be looking at potential defendants if it's litigation, or groups to negotiate with, who are operating in a global marketplace, often through quite complex corporate arrangements. And what we're thinking about here is the wider global interests as well as the narrow interests of that corporate. And there can be significant challenges in direct domestic litigation. The PNG logging example for it, very difficult to give people access to justice. The one advantage, if you like, of Myanmar in providing a legal memo to be sent to the Singapore Stock Exchange is there is the UN fact-finding mission. So you have got some evidence to rely on which to base a legal memo. And evidence gathering is a problem, but actually what you can do is work up some questions that people can answer. So you can help with evidence gathering. So in the slavery reparations case, one example is to get a family tree, see who lost their ancestors, whose ancestors were stolen. Can you work out who was affected by what went on in the past? Are there some simple things that people can do that provide an evidential basis? And coming back to what I said at the beginning, it's really important to see what knowledge you can gain. Don't work on the basis that you know the answers. There's a whole heap of law out there globally that you won't know. And you might need to be trained, you might need to improve your knowledge. More than likely, you're going to have to draw on people who are experts in their field. You have to accept that you are not an expert and you have to draw on those people who are. And sometimes you have to do that without any funding. Sometimes you can do it from open source material. So the legal memo that we provided to the Singapore Stock Exchange, we deliberately chose only to use open sources. So I'm sorry for the academics in the room, and I'm reasonably widely published, so I understand how important it is to be academically published. But it was of assistance, certainly in my opinion, for Justice for Myanmar to be basically able to find every resource that we put in the footnotes, that they don't have access to the academic material that we do. You then have to recognise the challenges that you're up against. And sometimes, occasionally, you'll feel like the only lawyer against the world. And that's why you need to reach out to have as much assistance as you can. There are some complexities that can become simple over time, such as identifying supply chains or identifying head office or subsidiaries or complex corporate networks. Justice for Myanmar have been quite good about that, but you can see on their website how they've found out who is investing in Golden City and what the corporate arrangements are. So there are some basic fact findings, things that you can do. You also have to think about personal risks, identifying who can speak, consider people's safety. Sometimes it's helpful to provide the sort of legal memo that we did, that in the voice of someone like me, that can be used by people who don't necessarily want to have their names on the document. I imagine there are lots of lawyers who could easily produce what we produce, but sometimes you have to step up and do that, but you have to assess your personal risks and your own personal safety. You also have to think about obstacles. That's obstacles in evidence gathering, limitation periods. the effect that corruption might have or bribery may have, or whether indeed there are litigation strategies around corruption and bribery. And they're really good examples that I paused for a moment to think about, because there's quite a lot of work being done around corruption and bribery, Transparency International, Action Aid in Australia, lots of organisations that you can draw on to say, well, what have you got? What's the latest? Where's the advice? Can you help? Who do you know? So you do find that you need to pull in quite a lot of favours if you are assisting in taking action against states or rogue governments, if you like, or indeed corporates seeking to operate in places like Myanmar. So then thinking about strategies, it isn't just laws or regulations or guidance or rules, it's all of those things. And you have to try and work out which one carries the most weight. Do you need them all? Are some for negotiation? Are some for litigation? And domestically, you might have both laws and regulations, particularly in a big business context. Global standards exist relevant to trade. We're all probably aware of bilateral treaties. Obviously, read the contract. There might well be quite a lot of information in a particular contract that requires proper behaviour towards those working in a particular environment. If we think about the Rana Plaza collapse in Bangladesh and the horrific deaths there, we start to think about that as an issue of modern slavery. And you can start to think about construction, modern slavery, contractual disputes, commercial liability for harm to individuals, as well as criminal liability for criminal actions, for money laundering, individual criminal actions. You have to think about complicity. So another piece of evidence gathering might be who and where, and whether someone individually was complicit, or whether there's some form of corporate complicity, or even corporate, or even in a corporate liability for genocide, or state responsibilities in terms of duties to prevent genocide. And all of those issues you have to start thinking about in these types of contexts, depending on what's going on as far as you can tell on the ground. And then you're thinking about sanctions, guidance, standards, policy, law, as well as child rights, rights for in relation to women, indigenous groups. So you can start to see how it does hurt your head. How much can I think about on my own? And you probably can't. You need to be able to manage what you're doing, manage it confidentially, separate your evidence collection, your legal research, cooperate as much as you can with as many as you can who have expertises in the area, and then think about what the available mechanisms are. And it might not be litigation. It might be delivering a legal memo to a stock exchange saying, hang on a minute, you've got the resources, you need to research what the risks are here, you need to do the work, you're at risk, your investors are at risk, you need to step up to the plate. And I understand our legal memo has now been sent on to the Japanese stock exchange, so I'm rather hoping it will have some more impact, even though frankly the content in there I'm sure most of you already know. You then have to take care of your team. Whoever's helping you, you have to make sure everybody can cope with the task. And all of that's quite important, because those people that you are seeking to assist or litigate on behalf of or advise need to have confidence that you can complete the job. So you also need to be careful to say, well, the job stops here. We can do this much, then we'll have a think about what we can do next and who we need next. And you might have your greatest impact via third parties. It may be that what you need to do is engage a media strategy or a social media strategy, or just identifying issues. And modern technology can be quite good. You know, again, Justice for Myanmar is pretty good about pumping things out via social media. There are lots and lots of other organisations, formal NGOs and ad hoc groups that have really made the issues at least identifiable. And that might work when one's considering regulatory expectations. There is a need for investor confidence. And you can start to match up the development goals with investor confidence. You can easily choose a development goal and say, well, what do you think about this as far as your investments are concerned? And even individuals are going to wobble. Whole investor groups might wobble. And it may be that there's some understanding that the investment can be done in a way either that everybody withdraws and that's not the way to go, or as sometimes corporate reporting for modern slavery works, is to engage in remediation, so that there is a forced improvement in places like Myanmar, Afghanistan. Now that may sound overly optimistic, but it is a strategy that is already being used in the context of corporate reporting for slavery and supply chains. That sometimes the mechanism is to say, well, we'll engage with our supply chain to make sure that it improves. And so you've got to think about which way you're going to go. Are you going to complain about the content of the corporate report, or you're going to try and find people who've been victims of modern slavery and issue some litigation? And you can think about big issues like modern slavery, legal logging, biosecurity issues, environmental issues. Can you approach the human rights abuses from an environmental angle, for example, or vice versa? What does the constitution of the particular state say? Are there some arguments in there that you might be able to use to develop a duty of care, or some language around a duty of care? What do the OECD guidelines say for multinationals? And even if it's not an OECD country, can you start to use that language in the context of negotiation or demanding? And that really brings me back to that understanding of sometimes you're working against states in some way, and sometimes you're looking for corporates to stand up and take responsibility. And particularly when you're advising, assisting those who otherwise don't have access to justice, focusing on the responsibility of others, making those others take responsibility in some way, means they have to shoulder the costs. And it may well be that you can be quite persuasive to say, well, the costs now are going to be a lot less than the costs if you don't do if you let this run in some way. And it may well be that you then have to say, all right, we're going to overshare now. We're going to give, share information, exchange information. We're going to try and help you recognize what the problem is. So it goes from me assisting a particular group to the corporates assisting the particular group, in the sense of the corporates changing the way in which they operate. So it's really what I tend to call a compliance mesh. It's a whole mesh of law, regs, guidance, domestic laws, regs, guidance, with international law, regs and guidance. And I think it's a huge ship to move, if you like, but there is a lot out there, most of which we put in our legal memo, that says, well, look, if we've got this core theme of risk, we've therefore got this core theme of due diligence. And in a global marketplace, due diligence means something bigger. It means that you have to look from the UK to Myanmar and everywhere in between, or Australia to Myanmar and everywhere in between. The due diligence really is an onerous and important exercise. And it might go as broadly as quality management in construction to alien torts in America. There are so many variables that what I've really tried to do is capture the significant burden that there is to conduct reasonable due diligence. I'm not going to read the whole of this slide. I know you can all read. And communicating those risks to those who are seeking to invest or engage or do business in places like Myanmar, Afghanistan, and so forth. And I'm sure our other speakers are going to talk about all the cases that are currently being negotiated or settled, the Vedanta liability of, if you like, head office and subsidiaries, and the German case, which was settled as a question of aid rather than litigation. So there are lots of mechanisms that are now out there for seeking to settle what is a very complicated dispute. So I was asked to do something practical. I hope that's what you wanted, Jonathan. I'm happy to take questions when you're ready. I've no idea if I've kept to time, but I hope that was useful. Thank you.
All right. Thanks, Felicity. So next we have Karen. And Karen, the floor is yours. Oh, Felicity, can you just, here we go. Okay. All right, Karen, the floor is yours. Thank you.
Great, thanks, Jonathan. Thanks for everyone for coming today. I'm joining you from the land of the Wurundjeri people here in Brunswick in Melbourne. So as Jonathan mentioned earlier, my background is primarily as a tort litigator. I've worked for a long time in private practice, bringing cases against both companies and states in relation to human rights and environmental abuses. But the last 5 years, I've been working, heading up business and human rights at the Human Rights Law Centre in Melbourne, which is a legal NGO for those of you who are not attending the audience who are not from Australia. And our work is broader than, than just litigation. Our business and human rights work essentially looks at trying to ensure that Australian companies operating overseas respect human rights, and where they don't, that they can be held accountable. And so we work on both law reform and trying to improve regulation and oversight by government over the activities of Australian businesses operating overseas, to engage directly with businesses about the impacts of their activities, and also to assist communities, individuals and civil society organisations who have been harmed as a result of companies' activities, to seek justice and remedy in Australia. And that's through a variety of means. We do use litigation. So for example, we're acting at the moment for the family of Reza Barati, the Iranian asylum seeker who was murdered by G4S guards in Manus Island detention centre back in 2014, acting in a case against G4S Australia and the Australian government in relation to his death. But we also assist communities and individuals with non-legal non-judicial complaints, and other types of strategies to engage with companies. And quite often we get approached by communities in relation to an impact. And the first thing that we do is kind of exactly what Felicity was mapping out. We sit down, we map out what the potential strategies might be, what evidence might be needed in order to develop some kind of complaint, and where it might be most useful to bring that. Because sometimes the answer is, in the case of multinationals, that that bringing action in Australia might not be the most strategic place to bring it, or there might be other options with better remedies and mechanisms. And it's about kind of trying to think creatively about what the options might be. If a company has bases in a number of different countries, there may be different avenues that people can pursue. So I've been asked specifically to talk today about some of the non-judicial complaints that we've brought, and in particular about the potential for communities and organisations to apply pressure on companies through complaints brought under the OECD guidelines for multinational enterprises, and how that can be used both to hold companies to account both for their direct involvement in human rights abuses, as well as how they may assist in indirectly applying pressure on authoritarian regimes or through businesses' relationships with those regimes. The OECD guidelines are actually something that's a little bit, even for lawyers, they're not necessarily that well known. So I'm just going to go through briefly, first of all, what they say and what the mechanism is, and then we can talk a little bit more about the potential use. And I'm happy to obviously have a more detailed discussion if it seems like it would be useful to anyone in the audience to consider that kind of mechanism in work that they're doing. So the OECD guidelines for multinational enterprise are essentially recommendations by governments to multinational enterprises about responsible business conduct. And they set out standards for responsible business conduct across a range of different areas, including human rights, labour rights, the environment, and bribery and corruption. And perhaps most relevantly for today's discussion, the human rights chapters of the guidelines, which is the most recent chapter that was added and is probably one of the better chapters of the guidelines, states very clearly that businesses must respect human rights and address adverse human rights impacts that they're involved with, avoid causing or contributing to adverse human rights impacts in the context of their business activities, and also seek ways to prevent or mitigate adverse human rights impacts that are directly linked to their operations by a business relationship, even if they're not directly contributing to those abuses. So they're quite broad. And the guidelines themselves and the commentary within the guidelines, which you can find readily online, they're published in a variety of different languages, set out more detail and commentary on exactly what's meant by each of those points. And in particular, the requirement that businesses carry out human rights due diligence about the potential impacts of their operations, and also that businesses, in the context where they're linked by way of a business relationship, must seek to use their leverage to influence the entity or government causing that, that adverse impact. So those are two things that are probably quite important when considering potential complaints that can be brought against businesses relating to their operations within the context of authoritarian regimes and adverse impacts that may cause. So unlike many other international human rights standards, the OECD guidelines also establish a somewhat unique government-backed international grievance mechanism for addressing complaints between companies covered by the guidelines and individuals or communities who may be negatively impacted by irresponsible business conduct. So each member state is required under the guidelines to establish what's called a national contact point to promote the guidelines and to also handle these kinds of complaints. So these are very variable. There is no kind of prescribed form that these must take, except that governments must have one. And they're very variable between countries. And before people kind of get too excited about using this mechanism, I just want to be clear up front that in general, this is a pretty, it's a pretty weak mechanism, especially compared to a legal case. So Australia now has one of the better national contact points internationally after a sustained campaign by civil society to strengthen it over the past 5 years. So complaints brought here would be brought to the Australian National Contact Point, which is based within the Department of Treasury. And they're now handled by an independent examiner, John Sutherland, who's a trained barrister and mediator. And he's the one who will independently handle any complaints that are brought to that mechanism. But national contact points are primarily focused on dispute resolution and trying to resolve complaints between communities and companies. So they can investigate complaints and make findings about whether a company has breached the guidelines through their business activities, and they can make recommendations about what a company should do to remedy those breaches. But those recommendations are not binding on companies, so they can't compel action. Their role is more to encourage action and to use leverage to do so. So essentially the way that the complaint process works is that, a civil society organisation or a community can directly file a complaint with the mechanism. They will first consider just basic things about whether it meets the requirements of the in order to be investigated under the OECD guidelines. So that includes, for example, considering whether this is really a multinational enterprise, whether there is a sufficient link to Australia, so whether the complaint should be brought here or to a different national contact point, and whether there's sort of the basic evidence required to investigate the complaint further. So that process takes a couple of months usually, and then they'll issue a finding saying that they'll accept the complaint or not. And at that point, that they will generally offer a dispute resolution service or a mediation service to the parties to engage in discussions about the nature of the complaint. If those discussions don't have a fruitful outcome or no agreement can be reached, then they can investigate further and actually make findings on the basis of the evidence that's presented to them. So there's, despite the fact that they're non-binding, these mechanisms do have some advantages over legal action. Firstly, they're free to use. There's no cost to filing a complaint. There are no standing requirements or requirements for having legal representation. So it's a mechanism which communities or civil society organisations can use themselves. And they're relatively quick compared to most forms of legal action. And they can provide a forum to apply pressure on a company or to engage them in discussion by requiring the company to provide a formal response and to justify their position. So they can be a good way of drawing companies into a prolonged set of negotiations or discussions towards a possible resolution. So we've found that the complaints to the AusNCP or to other NCPs are particularly useful in the following sorts of situations. Firstly, as a potential precursor to legal action, or where legal action isn't possible. So for example, it may be that you know that a company is about to start operations or is in the early stages of starting potential operations in a country with an authoritarian regime, and there are strong risks that their activities may end up or that they may end up becoming complicit in serious human rights abuses. It's often not possible to take legal action in that sort of situation, and so a complaint may be a possible kind of option in that sort of situation where actually you want to engage the company before the harm's done. Secondly, to seek further information from a company about its businesses, its practices or its business connections. You may have inadequate information on the basis of what you can find publicly about whether a company is linked to the authoritarian regime in a particular way, or don't have enough information about its supply chains. So it can be a way of requesting further information from the company that is more effective than simply just writing to the company and asking for that information. Thirdly, where a company, where you want to engage a company in discussions about their practices or their business relationships and encourage them, for example, to end particular relationships or to take particular steps to ensure that their operations are not contributing to human rights abuses. And finally, to apply reputational pressure on a company as part of a broader campaign, such as a divestment campaign. Generally, that is when these types of complaints have been most effective, is where there've been only one tool, I guess, in a wider, broader strategy around divestment or around putting pressure on companies. So just to give a couple of examples, and I'm aware that we don't have too much time, but a couple of examples of complaints that we've been involved in through the Australian national contact point, which have led to successful outcomes. One is a complaint that we filed on behalf of communities in Bougainville last year against Rio Tinto in relation to ongoing significant pollution from their Panguna mine there, and which the communities have been living with for a long time. And through the complaint and the discussions that ensued, we were able to get Rio Tinto to agree to fund an independent human rights and environmental impact assessment of the mine in July this year. So the first step towards the broader remedy that the communities were seeking. The second and probably more relevant to this discussion is one which we were more tangentially involved in, but it was a complaint brought by Cambodian communities against ANZ Bank a couple of years ago about the lending practices of the bank. So the bank had lent money to and helped to finance a sugar plantation involving a Cambodian company that was owned by a notorious senator and business tycoon in Cambodia, who had been, notorious for involvement in violent land grabs from communities across several provinces. And so that complaint was brought on the basis that the bank had undertaken inadequate human rights due diligence when they lent the money to the Cambodian company, and that they had, thanks, Jonathan, and that therefore they had breached their obligations under the guideline. And the request by the communities in that case was for the bank to actually repay the profits it had made on the loan. And that again was an outcome which, through a combination of campaigning and the complaint that was filed, they were able to arrive at an agreement with ANZ to repay the profits that they made on that loan, and also to improve their lending practices and due diligence standards in relation to when they were lending money to finance projects in places like Cambodia. So it created a much broader spotlight on the lending practices of businesses and the relationship and the direct human rights impacts that flowed from that, which I think is really important to consider when we're thinking about these kinds of situations involving authoritarian regimes. So I think there's real obvious potential to use this mechanism in relation to companies linked to authoritarian regimes in a variety of ways, either through financing, through joint venture arrangements with authoritarian regimes, or where companies' mere presence in a company may give rise to potential human rights risks. So, and many of you may be aware that just recently last month, Publish What You Pay brought a complaint on behalf of 245 Myanmar civil society organisations against an Australian mining company, Myanmar Metals. And that was quite a novel complaint in some ways, because rather than asking for divestment, which is what often these complaints are requesting, it was actually a complaint brought that Myanmar Metals had undertaken inadequate human rights due diligence and were irresponsibly divesting because their sale to a Myanmar partner company was more likely to mean that this mine in Myanmar would be developed, that in turn would attract militarized presence to secure that area and the like. So I don't have time to talk about that in that complaint in detail, and it's in its very early stages. So we have yet to see how the NCP will respond to that. And it's quite a novel application of the guidelines, but these are just some of the types of ways that that this mechanism can potentially be used. And we're more than happy to sort of have a discussion, offline with other organisations who are considering complaints of this kind. Thank you.
So next we have Meryl. Meryl, you have 15 minutes and the floor is yours.
Thank you. And thank you for organising the panel and the invitation to speak, and also to my fellow panellists for the wonderful presentations. Marco, I'm thanking you in advance. I'm going to be covering universal jurisdiction today, which is a massive topic, but I will do my best to give an overview of the key points and particularly practical tips if you were considering a case study. Just to note before we start that I'm speaking in my personal capacity and not on behalf of anyone or any company or institution. So yesterday morning, underneath all of the headlines about COVID and petrol prices in the UK, there was an article reporting that Jennifer Venish has been jailed for 10 years in Munich. Her husband, Taha AJ, an Iraqi national, is on trial in Frankfurt. The facts, alleged or found, are that Taha AJ is a member of Islamic State, and Venish bought and enslaved a 5-year-old Yazidi girl and her mother, who were prisoners of war. They held them captive, prevented them from practicing their own religion, and forced them to convert to Islam. Both were badly beaten. One day, Taha AJ chained the girl outdoors and left her to die of thirst in very high temperatures. Jennifer Venish was convicted of being an accomplice to a war crime, and Taha AJ is accused of genocide, crimes against humanity, and war crimes, and other crimes. The court in Frankfurt could be the first to hold an Islamic State fighter accountable for genocide against the Yazidis. Taha AJ was arrested in Greece in 2019 and transferred to Germany on the basis of a German arrest warrant. He is not, nor was not, German. His victims are not German, and his crimes were not committed in Germany. This landmark case is being prosecuted on the basis of universal jurisdiction. So what is universal jurisdiction? As the name suggests, it's a principle of jurisdiction. States will normally extend their criminal jurisdiction to crimes with a specific link to their sovereignty, for example, crimes committed on their territory, by their nationals, or against their nationals. Universal jurisdiction is available where there is no such link to the crime. It does not matter where the crime took place or who committed it. The basis is the nature of the crime. It concerns serious crimes such as those involved in the Taha AJ case. These crimes harm the international community or international order itself, which individual states may act to protect, even if there's not a classic jurisdictional link, or so the theory goes. The link is based on common humanity, and in the words of Hannah Arendt, the point of international criminal law is that an altogether different order is broken and an altogether different community is violated. And that gives rise to a different form of jurisdiction here. So another intricately connected rationale that states talk about is as a means to satisfy treaty obligations. For example, the Convention Against Torture imposes an obligation on contracting states to prosecute or extradite those who are alleged to have committed or been complicit or participated in acts of torture. And Panama's penal code gives a very good example of the this explicit link. It states that regardless of the law of the place where the act was committed and the nationality of the accused, the Panamanian criminal law will be applied to those who commit punishable acts foreseen in international treaties ratified by the Republic of Panama. At a theoretical level, there is some debate over whether this type of obligation should actually be classified as universal jurisdiction. But in practice, the requirement to prosecute or extradite is a helpful reminder that while factors like location may not be relevant to a determination of jurisdiction, they may actually be relevant to a decision to prosecute. States may consider whether extradition is available and whether it is more appropriate for the crime to be tried in a different jurisdiction, or whether factors related to a different location make it too difficult to prosecute at all. Whether mutual legal assistance is available, where the victims are, and crucially where evidence is located and how accessible that evidence is, are three factors that will play into what is appropriate. As a final point in the description of universal jurisdiction, it is important to remember that it is rarely, if ever, truly actually universal. It varies from country to country and does not exist everywhere. The constitutional and legislative frameworks in the country concerned will determine things like whether universal jurisdiction is actually available as a ground of jurisdiction, what crimes can be prosecuted under the doctrine, the conditions on prosecuting crimes, and what you have to show to commence an investigation, and how the prosecutorial process works. And that's before we even get into the impacts of different legal systems, civil law, common law, etc., which may affect your strategy. So I know the purpose of this webinar is to provide some practical lessons about the different legal doctrines and institutions that we're discussing. And probably the most important practical tip to take away from today is check the law and then check the policy. So that's a brief description of universal jurisdiction. And to bring this to life a little more, I'm going to look at some of the cases and draw some practical lessons from them. So to go back to the case of Venish and Taha AJ, there are two practical points that I'd like to highlight here. First, evidence. In these cases, there was one eyewitness to the crimes other than the accused, and that was the girl's mother. As will usually be the case when it comes to universal jurisdiction, the potential witness was not located in the same place as the prosecution. In fact, I think it was about 3,000 miles between them. An NGO called Yazda, which documented crimes against enslaved Yazidis, had interviewed the mother after she left the accused household. In 2018, one of Yazda's employees heard about the indictments in Germany and noticed the parallels in the mother's story. She was the person that contacted the German prosecutors and put them in contact with the mother. Ultimately, the mother went to Germany and was placed in a witness protection program. So this just underlines some of the potential complexities of finding evidence and the important role that NGOs, and particularly organizations that reliably document evidence, can play in securing a conviction. Having sufficient credible evidence also plays a key part in bringing about an investigation and prosecution in the first place. So in the UK, this factor is considered in the scoping exercise pre-investigation and in the decision to prosecute. As with all criminal proceedings, and particularly serious crimes, we also have to take into account how traumatic this process can be for the witnesses, as well as witness safety wherever they are. There may also be other barriers: linguistic, educational, cultural, psychological, and reports suggest that many of these came up when the mother testified in Germany. And these challenges are really not to be underestimated. So in the Kumalama case in the UK, which was a universal jurisdiction case based on allegations of torture in Nepal, the first trial collapsed after multiple interpreters were unable to fulfill their role as court translators in a trial that was scheduled to include testimony from 20 Nepalese witnesses. The second point to highlight from these German cases is the trials show us the resources and commitment that Germany is putting into prosecuting crimes in Syria and Iraq. In 2014, German prosecutorial authorities opened what they call a structural investigation into crimes by non-state groups in Syria and Iraq. And those who prosecuted international crimes know how difficult it is to prove some of the structural elements of the crimes. This has resulted in investigations into over 50 individuals. And like some other EU countries, Germany has a specialized war crime unit and has worked to better link immigration and refugee protection procedures with the police, the prosecution, and the courts to allow for an exchange of information. If you were considering universal jurisdiction as a strategy and were wondering where to go, this kind of institutional commitment would be a good place to start. One of the most talked about cases in any discussion of universal jurisdiction is the case against Pinochet, the former Chilean leader. Victims' lawyers filed complaints in Spain and other EU countries relating to crimes in Chile on the basis of universal jurisdiction. Arrest warrants were issued. In 1998, Pinochet travelled to the UK. The judge investigating one of the Spanish cases requested the British authorities to arrest Pinochet, which they did. 4 EU countries, including Spain, requested extradition. Pinochet challenged the arrest and extradition on the basis of head of state immunity. The case went to the House of Lords twice, and the House of Lords declined to agree that Pinochet benefited from immunity on both occasions, although for different reasons, and why the case went twice is a story for another time. So there are 3 points just to highlight from this case. So the first is immunity. Immunity is a doctrine drawn from the principle of equality of states. And it has many, many twists and turns and nuances and complexities that we don't have time for today. But for our discussion, in essence, it's a procedural bar to one state standing judgment over sovereign actions of other states or certain officials. There are also doctrines of diplomatic or consular immunity. And there's an active debate about how far immunity applies to serious crimes, although the ICJ's arrest warrant judgment makes clear that it's very much a risk factor. It was a battle in Pinochet, and it has come up in many other, including the German universal jurisdiction cases. Second, presence in the country or a country from which extradition would be sought. So Pinochet went to the UK. If he had stayed in Chile, none of this would really have been a question. And I would advise examining the relevant law or policy. So in the UK, to open an investigation for certain crimes, a factor that will be considered is whether the potential accused is in the UK or if there's a reasonable prospect of them returning to the UK. And the third thing to highlight here is politics, which was very prevalent. Political pressure was very, very prevalent in the Pinochet case. I think no description of universal jurisdiction is complete without a mention of politics, like many parts of international law, really. Political will is a necessary ingredient, and there are often foreign policy implications. So politics can affect everything, including evidence gathering. In the Kuma Lama case, it's, I think, safe to say that Nepal was not that happy about the arrest of Lama, and it ignored the UK prosecution's request for assistance in many things, including identifying and talking to witnesses. The doctrine of universal jurisdiction itself is actually sometimes also cited as an example of double standards and a broader power imbalance. And critics say that suspects from less powerful countries end up standing trial in more powerful countries. And finally, I just want to mention the universal jurisdiction case going on in Argentina concerning crimes against the Rohingya in Myanmar. The Argentinian courts are still considering whether they can continue, given potential overlap with the ICC investigation. And the point to make here is really an extension of politics. Consider the broader geopolitical landscape and how various cases in different fora might work together or detract from each other. And you can see in any sort of strategic litigation strategy how there are different forces that you might not even actually anticipate that help different cases to work together and bolster or sort of propel different cases. So that's a bit of a whistle-stop tour of some of the key factors underlying a universal jurisdiction case. I just wanted to end by noting that according to Trial International statistics, universal jurisdiction is really on the rise. So recent reports cite around 150 suspects under arrest or facing trial under universal jurisdiction in around 18 countries. And that compares with about 30 cases in around a dozen countries 4 years ago. So I'll conclude by saying that in spite of some of the challenges that we've just discussed, it's an increasingly important strategy to consider.
Okay, so next we have Marco. So Marco, the floor is yours.
Thank you. So I'm going to talk a little bit about tort litigation, which was alluded to by some of the prior speakers, specifically in relation to military juntas in Myanmar. As I'm sure folks know, Myanmar once again fell into military rule earlier this year, but this case was started into the prior period of military dictatorship. So in the early 1990s, the American company Unilateral, which is now Chevron, and the French oil company Total developed a major natural gas project known as the Yadana project in southeastern Myanmar, partnering directly with the Myanmar military to export gas to Thailand. And in the course of building and operating the project, the oil companies relied heavily on the military for security and other services. The military conducted forcible relocations of multiple villages and conscripted hundreds, if not thousands, of residents for violent forced labor. The influx of soldiers for the project also led to routine depredations by these military units, including rape of local women. And anyone who resisted the military could be tortured or shot. In one case, soldiers came looking for a man who had escaped forced labor. When they found his wife and infant child, but he was missing, they beat his wife and they kicked the baby into a cooking fire, and the baby died. When the pipeline was ultimately completed in 1998, it became the military regime's primary financial lifeline. There were real signs in the mid to late 1990s that the Myanmar military regime at that time was undergoing significant economic stress, somewhat similar to how the current regime is facing a severe economic shock. But then, as now, the natural gas project, and this was the first one, provided a much needed economic and financial lifeline to the military junta. Every year since 1998, the Yadana project has brought in hundreds of millions, or upwards of $1 billion annually to the military regime, and during about a 10-year period, the somewhat civilian government. It was the single largest source of income to the military regime during the late 90s and early 2000s, and today, this project remains the single largest source of income for the new military junta, although there are now several other natural gas export pipeline projects which also provide significant revenue to the regime. So in 1996, my organization, Earthrights International, took the oil companies to court in the United States over their participation in the Yadana natural gas project. So this lawsuit was not filed to challenge their ultimate support for the military junta or generalized authoritarianism, but it was representing victims of specific human rights abuses, including forced labor, rape, as well as the family of the murdered baby. We argued that the military was acting as the agent for Unical and Total, and that the oil companies knew that they were getting into bed with a brutal partner and were therefore liable under ordinary tort principles. The court in the United States found that we could not sue Total because it was a French company, but we proceeded to litigate against Unical for most of the decade. We relied partly on a law in the United States known as the Alien Tort Statute. Now, this is a very old law that allows suits in US courts for violations of customary international law, which in this case included crimes against humanity and essentially slave labor. But in addition to the Alien Tort Statute, we also relied simply on the centuries-old common law principle of transitory torts. The idea that if somebody commits a tort anywhere in the world, they can be sued anywhere they are found. And this principle is generally common to all of the major common law legal systems. In 2005, after the court ruled that we could proceed to a trial, Unical agreed to a landmark settlement that provided compensation to the plaintiffs and funds to assist with other residents of the pipeline region. And although Total had been dismissed from our case, French lawyers at an organization called Sherpa also took Total to court in French court. And later in 2005, they also announced a settlement with Total where the company paid over 5 million euros to compensate their plaintiffs and also create a fund for humanitarian assistance. So what's the relevance of this litigation to the current situation in Myanmar and elsewhere in the world? So unfortunately, these oil companies, Total and what is now Chevron, which acquired Unical, are still providing this massive income stream to the Myanmar military junta. And their effective support for military dictatorship is a little different than what it was 15 or 20 years ago. What has changed, though, is that under the current situation, we don't have much, if any, direct evidence that the companies are directly benefiting from human rights abuses, and that the gas pipeline project itself is leading to these abuses. Instead, we have a generalized support for a military regime of financing of military abuses. Now, I won't say that it's impossible to sue them over that financing, but it's quite a different case when you've got support on the level of investment and partnership with a brutal regime as opposed to direct involvement in human rights abuses, which is a much clearer case for tort liability in court. Another change since our cases is that the scope of the US Alien Tort Statute has been significantly limited by the US Supreme Court. And it has become significantly more difficult to bring suit under this law for abuses that happen outside the United States. Still not impossible, but its scope has been substantially limited. However, as I noted, we didn't necessarily need the Alien Tort Statute and we didn't rely on it exclusively. We sued under ordinary common law tort principles. And similar suits have been filed in other common law countries, especially Canada, where a number of suits almost exclusively against mining companies have proceeded regarding abuses that they have been involved with around the world and led to a landmark decision involving the Nevsun Corporation and its operations in Eritrea by the Canadian Supreme Court a couple of years ago. So this form of litigation does seem to be on the rise. And I would actually push back against the, Jonathan's initial comment about, in terms of rising impunity, because frankly, impunity frustrates me and aggravates me to no end. But I'm not sure that we've ever had an era in world history where we didn't face widespread impunity for serious human rights abuses. So I'd like to think that we actually, while the road is bumpy, we are developing a panoply of tools gradually, which is actually leading to greater accountability over time, including all of the tools that I the co-panelists talked about. Finally, I'd like to sort of bring it full circle to where Felicity started regarding, or similar issues to where Felicity started regarding the Myanmar military regime. We may not be able to sue, Chevron for its current activities in Myanmar based on the human rights abuse theories, but we have been looking into legal options.
I think we lost Marco there for a minute. Let me just. Okay, so Marco is going to return in a minute here. Hopefully it'll be very soon. I would encourage people in the audience to start submitting questions in the Q&A. We've already had a couple, but if you can go ahead and start putting them in, and then I can start compiling. Oh, Marco, you're back. Thanks for that. You froze there for a few seconds. So.
Sorry, I have no idea what happened. I was just going to say that while we may not be able to sue the oil companies for a direct participation in human rights abuses, that we do think there are legal options around essentially doing business with what more or less amounts to an armed criminal gang, and that companies face increasing risk from doing business in the context where the legitimacy of their business partners is highly questionable under international law. What happened in Myanmar with the coup, there is no question of the illegitimacy of this regime, and it's a little different than if a criminal organization took over a corporation and essentially stole access to their bank accounts. Would you continue doing business with that corporation under your prior contracts and paying money over to them, knowing that they were controlled by a criminal gang that was violating the law at every turn? And so I think that's an issue that companies need to be very careful of, and that we are exploring a number of legal strategies around at the moment. But I'll stop there. Thank you.
So thanks for that. So thanks to all the speakers for your insights, and we're opening the floor at the moment now for questions. So the audience, you're more than welcome to type questions in the Q&A. While we're waiting for the questions to come in, I do have a couple of comments and notes tied to questions of my own. The first one actually is just a more general question. This is for everyone on the floor. It seems like there's this underlying theme of trying to influence corporations that are in partnerships with authoritarian regimes, and trying to influence the corporation specifically to engage in some form of divestment. But it's the IHRB International, the Institute for Human Rights and Business. One of the things that they've noted is that there's also this, there are these potential complications from divestment that actually might cause more problems than solving them. And so while we have time, I just want to throw it out there for all the panelists is, what kinds of guidelines can corporations find about how to handle these kinds of scenarios? The example is a case in point most recently was Telenor in Myanmar, which was under pressure to increase its surveillance operations. It tried to sell and tried to divest, but then that caused an alternative problem in the sense that Telenor was the only Western-owned telecommunications company in the country, and by leaving, it left the people of Myanmar with all military-owned or at least state-affiliated telecommunications companies. So I'll leave that question for anyone on the panel about what kinds of guidance corporations can look for if they're in that kind of a scenario. So Karen, looks like you wanted to answer.
Well, yeah, I think it goes back a little bit to what I was saying earlier around leverage. I think there's a clear expectation set out under both the UN Guiding Principles on Business and Human Rights, the OECD guidelines as well, that companies will attempt to use leverage before simply kind of cutting and running from a situation, because that can cause a lot of problems. We deal a lot as well with situations where companies are alleged to be involved in supplying from companies that are involved in labor rights abuses, for example, and quite often the approach is simply to cut off ties with that supplier. That can lead to factories being closed down and workers losing jobs. So it's these are difficult issues, and I don't think I don't think we can pretend that there's an easy solution. I think in some situations there is a question, in some regimes in particular, I think there's a question mark as to whether it's possible for companies to operate ethically at all in the country. In some situations, in Myanmar, for example, it's tricky where you have a situation where there is a coup or a change of regime where a company has been operating in a country, and then what they decide to do afterwards. And I don't think that there are, I think that the answer is firstly to attempt to use leverage. Obviously, if that doesn't work, then the company may need to ultimately divest but it's about weighing up those different types of human rights risks that will result from their potential divestment compared to staying and engaging. But we often find that when we engage directly with companies, sometimes they will kind of talk about the value of staying and engaging, but unless you can see that's making a tangible difference over time, query sometimes whether those behind the scenes negotiations and leverage are really working to benefit people or just the company. So yeah, I think that would be my kind of short answer, but obviously every situation is slightly different, and you can't kind of apply a broad kind of brush approach to these situations.
Thanks for that. Marco, you wanted to add to that?
Yeah, I agree with all that, and I don't think there's a one-size-fits-all approach. I do think it's important to listen to the victims, essentially, the people of the country in question. So I know Felicity's been working with Justice for Myanmar in particular, and what they have said with respect to the oil companies that I was talking about, they haven't asked them to divest. What they've asked is for them to freeze their payments and to place them in escrow because they're essentially being paid over to an illegal counterparty. And they're violating their contracts because their contracts were not with this illegal criminal gang. So I think it's important that we don't try, as outside observers, don't try to simply prescribe a policy approach without listening to people on the ground who are affected and living through it.
Thanks for that. Meryl?
Yeah, I was just going to add, so Karen mentioned leverage and the UN guiding principles, and fundamentally, if the goal is to avoid adverse human rights impacts or adverse environmental impacts, then an assessment of what the impact of pulling out would be is a relevant consideration. And I think the commentary that UNGPs mentions this as well, like what would actually be the impact of pulling out, which, as everyone else said, it's a case-specific assessment. And then how far can you go along the road? Is anything changing as you exercise leverage? How much leverage do you have? I actually heard someone on a panel recently who was talking about supply chains and this very difficult question, and they were sort of orienting it around the idea of, okay, so if our goal in looking at our supply chain is how do we improve the lives of our workers and all the communities that our supply chain touches, what will actually be the impact on their lives and the economy of pulling out overnight.
Thanks, Meryl. Okay. So then this ties into a follow-up question. Marco had just mentioned this, but I'm going to hone in on this a little bit. Is this question about evidence gathering, right? Everything that we're talking about today is about evidence of some kind. However, for those of us who are residing in places like Australia, the United States, the UK, we're not on the ground. And a lot of the activities that are occurring are in other areas of the world. So do you have any advice about ways of gathering evidence, issues in gathering evidence, potential partners that are available in terms of storing or retaining evidence? So I'll open that up for everyone as well. Yeah, Felicity.
Yeah, I think it is always in litigation, you've got to have an evidential basis for a case that you're going to bring. So sometimes all these methods of negotiation or complaint or leverage or remediation, all of those softer approaches can achieve something with far less evidence. But obviously, if your strategy is actually, we're going to go for litigation, then there's a certain level of evidence that's going to be persuasive before the court. It may well be that you get corporate or state responses far earlier than when you've got chapter and verse in terms of human rights abuses. So there's also a sort of balance to be struck about how much investigation you need to do. But you can help. You know, I gave an example of a family tree earlier on. There's quite a lot that people on the ground can do, but often they need to be directed. And you know, if you need to keep people anonymous because they're providing information, you have to think about strategies to keep them anonymous but still gather the evidence. So I often think that the evidence is capable of being gathered, and there are some active people who could gather that evidence. They don't actually know what to look for or what you're asking for. And that's been my experience in all of the 3 cases that I've been involved with recently that I mentioned, is that actually, if you say, could you get this? It's remarkable how much people can get. And also, the internet is a wonderful thing. You know, in terms of maps and mapping what's gone on from one time to another and where people have moved and how environments have been affected, there are some horrific maps of PNG, once green, now grey. If you're trying to show that the logging has not been managed and there's a Forest Management Act, then you can pretty much show it's not been managed because it's gone. It's all really shocking. So actually, there's some very basic evidence gathering that can happen, but I do think it often needs some very basic direction. You're often gathering evidence from people who have no legal training, who are part of a group that has a particular interest, and often a political interest, and no real understanding of what litigation means. They're desperate for a lawyer to just rock up at court and get an injunction, and people get really engaged in building their own cases, whether that leads to negotiation or remediation or reporting or litigation is the next step. So I think I'll go back to what I said at the beginning. It's often quite hard for some organisations to get the sort of support that Karen has talked about from the Human Rights Law Centre in Australia, or from anybody. So what they have to do is sort of reach out to somebody who can give them some guidance. And there are sort of strategy books out there, but there's nothing that brings everything together. And as I say, that's what we really tried to do with that legal memo, not just bring it all together in one place as a legal memo rather than a fact gathering memo, but also to make sure all the sources are open access so that people can follow up and say, oh, well, what does that mean? And how can we understand that? And then, of course, there's the third sort of group or person that actually knows loads more than you do. And they're sitting on that evidence. Yeah. And that is always amazing. You suddenly find somebody who's got a box full of stuff in their office that's been sitting there forever, and they've gathered it and they've known exactly what they're doing. So I often think it's about communication, actually. So look, you know, you can have a UN fact-finding mission, which is fantastic if they were able to gather the sort of evidence that you need for litigation, which isn't always the outcome. But actually, human beings are very resourceful. And if you can set up a safe communication network, it is possible to gather a lot of evidence. I'm not saying it's always enough, but it is possible to gather a lot.
Karen?
Yeah, I think in terms of evidence, the most difficult situations tend to be situations where it's very hard to operate on the ground at all, or whether it's very hard for even local civil society organisations to operate on the ground. There's been some really interesting work done, you know, for example, in relation to the abuses of and mass detainment of Uyghur communities in Xinjiang in China, for example, through remote techniques, and people gathering evidence instead by engaging kind of Chinese-speaking investigators to look at various different search various different kind of web-based tools, including kind of where companies are linked to, and where which factories that they're kind of linked to and operating from. But there's still, you know, and there's also been a use of satellite technology in relation to investigating those abuses. But we have definitely found that, and this has been a real challenge with the COVID pandemic as well, is that, you know, the restrictions on travel and things have made it much more difficult to go and kind of work in country doing the kinds of on the ground investigations that we would normally do with communities. So you're much more reliant on technology and on people's ability on the ground. You know, in relation to Eritrea, for example, a lot of the evidence that informed the Nevsen case that Marco was referring to earlier was, you know, it was obtained from people who were refugees who had already fled the country, but who had previously kind of worked at the mine, because it's extremely difficult to kind of, you know, for people to just go and interview people, obviously, at the mine in Eritrea with the restrictions imposed by the authorities there.
Okay. Thanks, Karen. Thanks, Felicity. There's a question that was put in, and I know it was answered privately, but I think it's worthwhile for the larger audience. Was precedents regarding third-party entities, so like arms corporations, like arms companies that are selling weapons. And so these aren't necessarily the kinds of companies that you would find with full transparency. And so what are the precedents, or what kinds of things have been done with respect to those? So Marco and Meryl, I know you already provide answers, but if you could just share that with a larger audience. So Marco, why don't you go first?
Yeah, I'm aware of some litigation similar to what I discussed against companies providing military hardware, litigation in the United States against US companies. The most high-profile case was a case against the Caterpillar company for providing military bulldozers to the Israeli Defense Forces, which were used in house demolitions in Gaza, including deaths that resulted from that. And that case was unsuccessful. It was dismissed under the U.S. political question doctrine for reasons that were highly specific to that case, but also probably having to do with the fact that any case involving Israel in U.S. courts is likely to result in a negative decision. I believe there have been some other attempts, but I'm not aware of any successes to date. But I think certainly if you did find a company, certainly in the United States, if you found a company that was knowingly selling arms to a regime that was actively engaged at the time in serious abuses, that you could make out a case in that event. You know, usually the companies that are involved are not amenable to suit in the United States, as far as we've found.
Thanks. And then Meryl, you had something to add?
Yeah, I was just referencing the CAT campaign against the arms trade for a judicial review in the UK. So it didn't actually target the companies, it targeted the government's decision to grant licenses to export arms to Saudi Arabia without really considering properly whether there were breaches of international humanitarian law implicated. And those cases, I actually worked for some of the interveners in the first case, because there's a second application that's just been filed. And those cases related to some of the EU guidelines about the assessment that governments have to make before they grant the licenses, and also the evidence that was available and what was being considered or not. And so there were sort of submissions, various submissions about facts. There were submissions about different legal obligations that had to be considered, and it's an interesting series of cases. I noticed actually that someone else has posted some information in the Q&A. I actually wondered if I could just add a couple of points on the prior question, Jonathan. Do you mind?
Yeah, no, don't mind. Go ahead.
So I was just going to say that in all the strategic litigation I've done, it's been crucial to have links with NGOs on the ground, particularly when it comes to witnesses and witness work, so that you have someone there along the way that's working with the witness and ensuring things like consent and linguistic assistance and psychological assistance, and also contextual information. And then the other 2 points I wanted to quickly add is first that obviously if you can record the evidence as quickly as possible, that really helps with any case, because the longer the gap, the more that there's fallible memory, or the more difficult it is to authenticate something, the more difficult it becomes to use the evidence. And then the third point is obviously a lot of evidence now is electronic, like everything from WhatsApp messages to videos of what's happening. And the IBA, the IBA Eyewitnesses on Atrocities project has been developing basically an app and different software that can be used and adapted to different contexts to upload and authenticate and work with that type of evidence. So that might be a useful resource.
Thanks for that. And so the comment that was in the area was from Rawan Araf. So thanks for that, Rawan. It's about the work by the ECCHR regarding arms exports in Yemen and the actions in Italy. So we're starting to get short on time, but there was one other thing that I wanted to mention. And so this was one of the other common underlying themes that sort of arose out of today was all of you had mentioned that there were these parallel efforts that occurred in different countries, roughly the same time. So it seems like there are very interested actors in different countries who all want to do similar things, which poses this possibility of coordination, right? If there's systematic, coordinated campaigns by multiple actors in different jurisdictions with respect to the same issues. So, this is not something that's been mentioned, but it seems to be one of the logical implications. So I'm just curious, and for all of you, what kind of potential do you see in that with respect to the ideas that you posed today?
So I think I would highlight that coordination is essential to all of these efforts. So Felicity made the point earlier about coordination in the gathering of evidence. That's just in a sort of maybe in one locality, but it could of course be all over a country. Most strategic litigations that you'll work on, there'll be maybe a national case, an international case, advocacy efforts with the government, all coordinated, and that will maybe just be one or two NGOs running that. And then you can think about coordination on a much broader scale. And as soon as there's sort of interest, or you can see the potential to build up to build up pressure from different angles, then coordination across country also becomes incredibly important. And the coordination at that level, it can be really a full-time project management job, but the more coordination there is on all of these levels, the more effective and less time and less sort of divergent directions you'll find.
Felicity, I thought you were going to make a comment. I'm
Yeah,
sorry,
well,
I
look,
cut you off. But
I
yeah.
couldn't agree more. You know, I think I rattled through quite a few strategies earlier on, but absolutely. And it might be coordination in relation to evidence gathering, but also I mentioned expertise. You might need to coordinate a bunch of experts who need to help on separate things. You might need to coordinate a bunch of lawyers in a load of different countries. And it is largely a project management task. I think the root of it comes to listening to the people who are instructing you as to what they really want, because you could come up with a million different strategies, but ultimately you might have to choose the one that you, if it's going to be a client, really wants. So, and that might not necessarily be, sometimes it's not necessarily the, I don't want to use the word best choice, but I think linking back to what we said earlier on about the best choice might feel as though you've got to pull out and that you've got to persuade the corporate to pull out of a particular country. But in fact, it may be that the people on the ground want the business to continue in the way that we discussed, but to apply the leverage in another way. So all of those strategic decisions ultimately have to come down to what the people on the ground want. I'm really particularly interested in, sometimes what they don't want to do is evidence gathering at home. They want to have action against external jurisdictions. So I've popped into the chat 3 examples of cases where there's been jurisdiction arguments or settlements in different ways by Germany in relation to Syria, and the Vedanta case I talked about earlier on. So this coordination can be in a different jurisdiction. You might actually be coordinating outside of benefit to the country that you're dealing with. So look, that's a slightly rambled way and to agree with Meryl that ultimately it is a project management task and you have to work out which project you can manage and how much of a project you can manage. But I agree, coordination is key.
Marco.
Yeah, I mean, I fully agree with all that. I mean, I'd say that you know, we're often facing threats that are multinational and transnational in nature, and we need to operate the same way in response. And so, you know, my organization, we have offices in the United States, in South America, and in Southeast Asia, and then beyond that, we work, you know, with networks of public interest organizations, local civil society groups, community organizations, attorneys, all around. And all of these partnerships and networks are essential to combat the problems that we are facing. So, and, you know, I'm fully supportive of broadening those networks and strengthening those wherever necessary. I don't think there's a single case that we've worked on that doesn't involve partnerships across borders and between organizations and individuals and such. It's, you know, it's always a large group effort, and it's really the folks on the ground that are the most critical to that effort. You know, the lawyers are kind of interchangeable, but you know, we couldn't do this work without folks on the ground, and they're the ones who, in some cases, are really risking their lives as well, which is another issue for the fact and evidence gathering question you raised earlier in terms of how to do that ethically in a situation where folks may be risking their lives because I never want to put someone in that position. In most cases, we find that the people who care about these issues are, you know, are more, or have a higher risk tolerance than we would be comfortable with in many cases. But it is a tricky issue to face.
So we're over time. And so I just want to go ahead and close with that. So I think those provides good closing comments, and thanks to all the speakers. So Felicity, Gary, Karen Adams, Meryl Laurie Wright, and Marco Simons, thanks very much for your insights. And thanks for the people who put their questions. Some of you put questions into the chat space, but that's okay. I tried to relay them as best I can. And this has been recorded, so it will be available for anyone who wants to take a look at it. And for anyone who has further questions or comments, you're more than welcome to contact me, and then I can go ahead and forward the questions on to the relevant parties. But thanks to all the speakers. Thanks to Gian Teo and the rest of the College of Law marketing team for the hard work and getting everything set up. I know that it's usually quite a thankless job, and it's always behind the scenes, but I wanted to give particular attention to that staff as well. So, and thanks to the audience, and let's hope that this provides a useful starting point for further considerations in your respective locales. So thanks everyone, and take care. Bye.